Welcome to a CNBC special on intellectual property. Now, the World Intellectual Property Day is upon us this year to be held under the theme Critical Role of Intellectual Property and Innovation for Youth Entrepreneurship and Start-ups. In Rwanda, IP conversations and understanding continue to pick up steam, but there are still so many questions. Though today we would like to tackle one particular question. Can we marry IP and innovation as a basis of competitiveness? Now, to help us break this down, we're joined by a panel of experts led by Mr. Richard Kayibanda. He's the Registrar General at the Rwanda Development Board. We're also joined by Dr. Mafini Doso, Project Management Professional, Economist and Policy Analyst, Project Lead, Smart Specialization in Innovative and Informal African Economies at the World Intellectual Property Organization. We're also joined by a good friend to CNBC, Mr. Arthur Rugango, Managing Partner, Cedar Aklo, and Pascal Ndize, Chairman and Founder, Pascal Technologies. Thank you for joining us, gentlemen and ladies. So it's only right, I think, we start by speaking to the lady. Ms. Mafini, IP and innovation for the informal sector being key, but I wanted you to tap into your experience in regards to the journey when it comes to intellectual property over the years. How has that translated and why is that important for an economy that is growing like Rwanda's?
Thank you very much, Arthur, and I'm very pleased to join you today. Hi, everybody who are following us, and also to my co-panelists. Just to be brief, I guess this is the first round, so I think the pathway toward growth is about, I think Rwanda get it well, is about how you bring innovation to address your different sustainability challenge, your different societal goals. How do you tackle them? By bringing new kind of products, new kind of processes, new methods of organization, or new modes of commercialization. Now, we know intuitively, or as a basic rationale, that IP is supposed to protect innovation. We have a lot of specialists here, so we know also that different IP are protecting different facets sometimes of the same innovation. The thing which is crucial for me as of today, considering both the difficulties our economies and the global economy has been through, but also considering the global integration and the African integration through trade, it is even more important to innovate and to transform this innovation into jobs and income. Now, the IP comes into the story as a protector of innovation, but also if you take items such as trademarks, this is also to protect or to distinguish your businesses. So I want to be precise that one IP doesn't go with one innovation, especially in the world where innovation are very complex and where they mix both technological and non-technological aspects. So it is also about valuing and about protecting the non-technological form of innovation aside from the technological form of innovation. And this will go even more complex, considering also the competition we are embedded in, both as nations and also as firms or companies, or even as individual actors. So we are still in Africa looking at the IP statistic at the beginning, let's say, of the path, considering the IP, but not at all considering the innovation. So for now, I would just like to stop on this point and let the other also take the floor. But this is my first word, considering the critical role of IP for innovation and where I think we are going in which context.
Dr. Muffin there is laying the groundwork for what should be an interesting conversation. I want to bring Mr. Richard Kayibanda, Registrar General at RDB, into the conversation. Now, RDB has been behind the IP policies and understanding of IP, policy and regulations in place. Now, could you just help us break this down? And before we start running, so let's walk for a minute. 2018, when RDB started leading this venture, what steps have been taken? What are the national laws and treaties in regards to IP?
Thank you, Arnold. Building from what Dr. Mafini said about innovation and that IP protects innovation, Rwanda has not lagged behind in this regard. It has understood the role that intellectual property, commonly referred to as IP, has to play in encouraging innovation, in encouraging creativity. So it is in this regard that from around 2009, Rwanda has reformed the policy and the regulatory framework, and more importantly, in 2018, a new intellectual property policy was put in place to ensure that Rwanda as a country continues to align its policy directions with international new developments, international conventions and treaties that are meant to protect intellectual property, because we are now in a global market where different products, services that are being produced are not being offered to the national or local markets only, but they are being offered in this global market that has become smaller thanks to innovation and technology. So the main aims of the revision of the IP policy in 2018 was to review the existing legislation, to adapt it to these new international treaties and all the ones that were not yet signed by Rwanda, but also to ensure that there is there are well-coordinated mechanisms in place to ensure the implementation and enforcement of these legal instruments. So as I indicated, we are now working on the review also of the 2009 intellectual property law to implement new policy guidelines. But in addition to the 2009 law that governs intellectual property in Rwanda, Rwanda is signatory to a number of conventions, such as the Paris Convention that deals with industrial property. These are trademarks, patents, industrial designs, and so forth. It's part to two other instruments, such as the Berne Convention that deals mainly with the copyright and related rights, but also so many others, such as the PCT, that is the Patent Cooperation Treaty, that basically enables protection of an invention in multiple countries using a single filing. We can also mention the Madrid Protocol, which also Rwanda is party to, and enables the filing of a single application to protect your trademark in multiple countries using a single application. We do have also other protocols at the regional level where Rwanda is a member of the African Regional Intellectual Property Organization, and all these offers a number of instruments that enable protection of intellectual property at regional level beyond the boundaries of the country. So all these are meant to encourage and foster innovation, which is indeed, as I have mentioned, encouraged by intellectual property rights that are offered to innovators and creators over a certain period of time by granting them some exclusivity so as to reap from their efforts by gaining some financial benefit, but also getting recognition for their creations. At the same time, this IP system balances their interest with the general interest so that we can continue to build on innovations and come up with more upgraded, if I may say so, or better solutions that help to tackle different societal problems and issues.
Very detailed answer there. And, you know, it's one thing to have laws, to have treaties in place. It's another thing to implement them and, of course, enforce them. So there are people who deal with this better than us, and those are lawyers. Luckily, today we have one on this panel, Mr. Arthur Rugango, the managing partner at Cedar Law. And I want to talk about enforcement of these laws, because Richard has outlined what Rwanda is part of, the laws regarding IP, but the enforcement of that, is the country enforcing this, or what could be done to tighten some of these loose ends?
Enforcement, I count it back from the time of 2009 when the law was passed for the IP law. Prior to that, there was a law in the 1963. So the last 10 to 14 years have really been, there's been growth, considering IP is a very dynamic sector, and they have challenged the government of Rwanda to step up to do the great job they are doing today. And if I recall, prior to 2009, there used to be a small department in Ministry of Commerce that was completely unknown to the public, and it was more like a bureaucratic office that stayed indoors. So after it was established in RDB under the Registrar General's office, action started. And so through that action, there was a lot of awareness. Then also the 2009 law generally put to speed a lot that was lacking in the economy, though they would say that there's a lot of room also for growth, which now they're also trying to review. And we have given our inputs on the constraints in the sector. However, the things to note out, the sticking out issues probably would be they have a backlog of cases lately after COVID-19, the post-COVID-19 era. We're still in it, but we believe we're out. So, they receive different applications from the local applications, and then there's the international applications which come. So there are about 3 systems now here. So we're talking about the local applications, then we have OWAPI, and then we have a REPO, and then we have the Madrid protocol. So all these things have a backlog, and they are trying to deal with them, but then we're seeing an issue. So probably they're trying to resolve is the staffing issue. So that's one sticky area that we would say they are trying to address, but there's still room for improvement. And then probably we can also say that also to commend their actions, the legislation provides registration of trademarks, for instance, for 6 months, but they're able to deliver in 4 months, which is a good thing. And they are trying to keep up with the process. And also, I would say lately, they have really stepped up on their campaigns, and the local registrations, especially trademarks, which is the leading way in IP, and for the awareness, have increased tremendously. And we are just seeing issues of names, the Rwandan synonyms that clash with the same meanings. And as a result, we're seeing issues where you can't resolve which mark can be registered versus another, because everyone is claiming the same name traditionally and they have the same meaning. So this is challenging the international norms of IP registration. And I think it's a big challenge for the IP office in regard to that. So I think that's what I would start in for now.
Arthur, there trying to look at the glasses half full. So, Mr. Registrar General, for now, you are in safe hands, but I'm sure we're going to be coming back to him a little bit later to understand what are some of those loose ends that he thinks could be tightened up. I want to bring someone in the private sector as well into the conversation, Mr. Pascal Ndize of Pascal Technologies. I want to tap into your experience when it comes to innovation. And why something like, intellectual property rights are important for a company like the one you run.
Thank you so much. To have your brand be protected by institutions like RDB is much more powerful regarding to copyright and the security of your brand. My testimony can go to RDB. When I approached them to protect my brand, it was so much easy to more than other country where we are operating from. RDB takes not more than a month or two to have your copyright and your IP protected. But other countries where you can take even a year, normally is between 6 months and a year. But really, true speaking, thank you to RDB for protecting made in Rwanda brands. And I can encourage other business follows from Rwanda to approach RDB to protect their product. Is much more safer to have your brand being protected.
Thank you there, Pascal. And I want to bring Richard back into the conversation. When it came to implementing of regulations and ministerial orders, we've had companies go ahead and do what one will term as simple, quote unquote, pick up one name, and let's say a company is called Quizera International. Then the other day, someone starts, a former worker of Quizera International sets up Quizera Global. How do you deal with such situations?
The laws that we implement here in Rwanda have common principles that we would find elsewhere in the world, and that's why you've had me mentioning different international conventions, because the principles are more or less the same. So in our case, in the case of Rwanda, I would say that the more people become aware that intellectual property are assets, valuable assets like others, then you start having, among others, as an indication, though negative, but cases of infringement on trademarks and so forth. So the legal system should have mechanisms to resolve such disputes. So specifically in the case of Rwanda, first of all, to be able to register or to protect your intellectual property asset, depending on it, there are requirements that are spelled out in the law, and then it has to meet those requirements. Your applications, your new idea, if I may say so, let's use the example of a trademark that you have given. It has to meet certain requirements. So if they are met, then the name, the trademark is protected. And if it does not meet them, then it cannot be protected. So it has not to be imitative, among others. It should not be confusing. It should not be descriptive. And it should be able to distinguish your goods or your services from those of other enterprises that using the same or are dealing in the same products or services. So those are the requirements, the basic requirements, and they are looked at and considered when granting protection. So in the case of Rwanda, I would say that we apply the principle that the first person to file is the one that is protected, and whoever tries to imitate the same, imitators are clever, they will not reproduce it as it is, they will try to twist it, but again trying to confuse the consumers, the service consumers or consumers of goods, so that they mistake the goods of one enterprise to those of another. But the way they would twist it, then if it does not pass the other standards, then it should be dealt with by competent organs. So I would say that as the Intellectual Property Office, when such disputes come, all we do is mediation, which is an amicable approach, because the law does not give us powers to act in a judicial way. So as the IP office, we would handle it in an amicable way. But if an amicable solution cannot be reached, then the offended, the aggrieved party is entitled to take the case to competent courts, which would, among others, using the same standards, award damages, but also issue injunctions to stop the infringing goods or services from the market. So we have, I would mention that at the same time, some of these infringing acts constitute offenses that attract criminal sanctions, and these are dealt with by competent organs such as the Rwanda Investigation Bureau, or the National Public Prosecution Authority, and then the judiciary that comes in to take a decision. Something else that I need to mention is that also when these infringing goods are coming in from outside the country, the Rwanda Revenue Authority, the Customs Department, is empowered to stop those goods, confiscate them, and prevent them from entering into the market. But something important that I want to end with is that the copyright, the intellectual property rights holder are encouraged to play a very active role into this and report these infringing cases to competent organs for effective handling. So that's how I would tackle it as of now.
Dr. Mafini, thank you very much, Richard. Dr. Mafini, bringing you back into the conversation, right? You have a situation where innovators, the likes of Pascal Technology or other companies, would say, not one person can have an idea for something. And someone goes out there, they set up, they have their idea, and then you go ahead, when they go to check at Richard's desk, they find out that there was an IP in regards to that particular idea. So couldn't that in a way deter innovation, especially at a time when a continent like ours needs it?
I was listening for carefully, because in my mind I was also kind of comparing with what we have in Francophone Africa, for example, in Cote d'Ivoire and Cameroon, where we don't have IP laws. And I was thinking together also about the African Continental Free Trade Area. And I was wondering, because I have questions too, sorry, I'm a researcher. So I was wondering how the Rwandan strategy would face this opening of all the borders. Now, I'm coming back to your question, but I wanted to ask also this question. I was wondering, because I think some other countries can also learn from what Rwanda has been putting in place in some time. And I'm insisting some countries in Africa do not have IP laws. So if, for example, Pascal come to Cote d'Ivoire and he sees, and he probably will be, another product called Pascal Technology, so it means that the effort that we are doing really have to go continental-wide in a way or another. So that's one thing. Now, if you look at the empirics, really, I want to come back on this. If you look at the empirics at the relation between intellectual property rights and innovation, without distinguishing first, but in general, we talk about trademark and patents, you can see that the more the economy is using IPR, at some point it can deter innovation. First, because you will have a kind of name cluttering, you will have a kind of similar name, and you have also companies that actually are preempting all other companies by putting trademarks, etc., before the others get to the market. Big companies have this issue too. So I think what is more important, if we come down to the level of the firm, I've just finalized IP survey on the small startup network in Ivory Coast. And I was asking them, and the top startups, with important turnovers. And I was asking them which kind of intellectual property right you use. So as you say, trademark came as the first, but some others were combining patents, and even others were adding the industrial design for the same innovation. So I asked them, why are you even doing that? Because as Richard say, our legal system, at least in West Africa, where I'm from, cannot really protect your name or your invention outside of Cote d'Ivoire, outside of Cameroon or Congo, for example. And they told me, we have this first because it is a personal matter. It is a personal investment. It's about the personal reputation and the effort we want to put as seriousness in our work, our firm, our company, the way we see our company, the prospect about the technological growth and the market expansion of our company. So first, it's a matter of identity, and it's a matter of I don't know how to say that. It's a matter of self satisfaction. This is the first. The second one, some others were telling me, you know, when we go to international investor, I am a startup producing, for example, in this case, was producing internet using the light. The solar energy in the rural areas in West Africa. And I say, when you go to an international investor, maybe it funds or an international bank or even an international donor, well, look, if you have patents and you have trademarks, you are also sending a signal. You are saying, look, I'm good at doing technology. I have some technological capabilities that are legally recognized, but also I'm combining marketing capabilities that are also legally recognized. Now, it's also inventiveness, of course, but you see that it's also that this IPR can also be used as a signal. So they can be used from the point of view of the owner of the firm, because it's a matter of self-satisfaction, of growth, of how you see your firm within the big, let's say, environment of all the firms. And it's also a matter of sending a signal to the investor. And then lastly, it's also a matter of sending a signal to the market where you are intending to. Most of the firms I've surveyed say, we want to go beyond West Africa. We want to go toward Africa. So if you go toward Africa and you don't have a strong brand, this will be very, very, very difficult, not only legally, because maybe you are not protected in this area. For example, Archie was talking about OAPI and ARIPO. There are differences in between the Francophone countries that are covered by OAPI and the other ones. So also there, we have to make something. So, I mean, those are the different way you use that. So I think we need more to know more about how the startups are using IPs, because in some cases, some startups were not even aware that they could actually use patents or trademarks, etc. Now, just my last point, I wanted to add also, I asked some of these young startups and I told them, okay, can you tell me what can we do to help you? So I've noticed that many, maybe Archie can tell us more about that, many in the software services, so some are proposing application and stuff like this. They say, we don't know what to patent in our technologies. In the same group, there was someone providing on-demand services with specific technology, another one having an integrated platform of payments, and another one having a kind of health bracelet with the QR code. One of them could patent in another country next to Cote d'Ivoire, Benin, and the two other didn't know. So it means that even the one that have the technologies maybe do not know how to or are not aware that they could even patent. And I have the impression that it is stronger in Francophone Africa. So that was my many points. Sorry.
Quite the mini point there. You left us with a question there, and I hope Dr. Richard, you're ready to answer that question. Sorry, Richard, you're ready to answer that question when we come back to you. Arthur, bring you back into the conversation. There seems to be a gray area when Richard was explaining when it comes to how the laws are enforced and implemented. And I wanted to have an understanding of the time for implementing these laws. And I want you to expound on your earlier point where you're saying, 5 steps forward, we've taken more steps forward, you're looking at the glass as half full. Could more be done, and in what capacities could more be done to ensure that this doesn't only limit innovativeness, but also protects the companies that go out of their way to go to the Registrar General and have their IPs registered?
The more, the merrier. That's my take on it. The more challenges in the markets, it gives us work as practitioners also to figure out how to resolve the issue, because when the laws are put in place, they have to be tested. And when the laws are tested, then we have to give feedback. So this is the experience we've had in the last 10 to 14 years. The law for the 2009 law had plenty of gaps, and as a result, they're reviewing it with a lot of input from the experience in the market. So in a nutshell, I would say we need more and more challenges, and with the more challenges, we'll find solutions. And also with, there's so many issues that cannot be discussed, but then they're always tabled and there's room for growth and solutions that are being created by it's more like a sandbox process with the registrar's office. So they're open to receiving the challenges and then try to find solutions. But also going back to the big issue right now, I would say, is training. Training of let's say, the judiciary. The judiciary needs more and more awareness on how to adjudicate these new challenges in accordance with the law, and also consulting the right experts in the different sectors of IP, and trying to come up with a good precedent in the market, and which will keep addressing new and newer problems. So I find that is a very, very wide scope of issues. But going back to how it is also dealt with, I would say, like South Africa, which is the largest economy so far that is advanced in IP, it is open for all, and all the issues are resolved in court. So I wouldn't directly say the Registrar General should recommend that immediately, because IP is its growth is determined by the economy also. The larger the economy, the more issues you have to tackle. So you can't copy and paste what has advanced in South Africa and say the courts will deal with everything. So it's a step-by-step process that the Registrar General's office is trying to deal with, and then now they're looking at the reviews of the laws, and now when it comes to more challenges, we'll keep addressing them.
Again, a very optimistic view there, Arthur. We'll be coming to you later on for closing remarks on what could potentially be the way forward in marrying these two. I want to bring Pascal into the conversation. And Pascal, I want you to expound by giving us examples in regards to your company. You've gone to RDB, you've had some of your products are registered, the intellectual property there registered. What are some of those, and why was it important for you to protect them the way you did?
Thank you so much. Basically, my idea was to take a Rwandan product to across Africa, even beyond Africa, and our product should be protected. As Dr. Dasso said, some of the countries in Western Africa are not protecting much the innovators' brand and products. But as RDB approached RDB and they give me the idea, say if you're going to Congo, also you need to protect your brand in that country. So it's country to country. My idea, and when I finish my innovation, or when even I'm still thinking to innovate something, I protect my ideas. So I will do some small booklet that is my idea. I'm gonna develop the product in a couple of months or a year. But before anyone maybe may steal my book when I'm still designing it, it must be protected. So it was my idea. First, I have to approach RDB and protected my name locally. When I moved to Kenya, also I had to Kenya authority to protect my brand. When I went to South Africa, I went to ICASA to protect my brand. So as Arthur said, also is not copyright from one country to another. The challenge you meet in Rwanda is not the challenge you're gonna meet in South Africa. It's not the same challenge you're gonna meet in Ghana. So, but in Rwanda, to protect your brand, it takes a short period because their team value your idea and your brand. But the other countries, it may take longer and also does not protect your brand much as you want. But as the owner of the brand, you are the one who has to work harder. My brand is copyrighted in outside. Is someone having the same brand as mine outside? So you are the one who's gonna work harder than the government authorities to protect your brand. So, and what Richard said again, if there is something you find out, let me say in Rwanda, maybe someone copied your brand. There's authorities before even you go to court. There is an organization called Kigali Arbitration Center. So you approach them before you go even to court to say, okay, guys, I have someone who copied my brand. Can you put us together? We sit and talk about my brand being copyrighted, being used. So that is what I can even thank the government of Rwanda to put centers like that locally, even though if it's international companies that copied your name and your brand, you approach KIAC. KIAC will also approach maybe when I put an example, the Ghana authority to seek amicable solutions for your copyrighted brand. So I think locally we are protected. Other countries are not protected as Rwanda, but there is a way you approach international communities in Rwanda. They can assist innovators who think that their brand being copyrighted. Thank you.
Thank you, Pascal. I want to bring back the Registrar General with his closing remarks. Mr. Richard Kaiband there, and I want to piggyback off something Pascal has talked about. You know, the status of protection of IPRs for both local and international registries. Where do we stand right now? You hinted on it earlier. And what are the other steps being taken to ensure that this holds more water than it currently has?
IP is a dynamic domain. So we, as the world evolves, as new technologies are coming up, new approaches of doing things are coming up, new initiatives are coming up. My fellow panelist, Dr. Mafini, mentioned the AFCFTA. So all these initiatives and new ideas, innovations and approaches coming up, every system, whether at country level or regional level, there is need to keep improving the existing systems, the existing institutional, legal, and regulatory frameworks, so that gaps that are hindering innovation, that are hindering startups, entrepreneurs, removed from their way, so that we can prosper as nations, as continents. So as I indicated, local at the national level, there is this constant exercise to look at the institutional framework, the legal framework, the policy framework, to see if they are responding to the needs of the business community. But also at the continental level, at the regional levels. For instance, we have two organizations that Dr. Mafini has mentioned, the OAPI, that is more or less the French-speaking West African region, the ARIPO, that is more or less the English-speaking region of Africa. So there are a lot of initiatives coming up, trying to see how the business community, the innovators, the creators can be facilitated. Like if an entrepreneur like Pascal came up with an innovation, a new technology, how can it be made easy for him to protect in as many countries or in as bigger area as possible, so that he can reap from the efforts that he has invested. So there is this continuing effort to review and rethink all the entire IP system. So Rwanda is not lagging behind, but even at the continental level, Rwanda is and will be playing the role that it thinks it is proper to play.
We need data, and we need access to data on patents, on trademark. I'm a researcher here in Europe, yes, but also there are researchers in my country back, and they don't have access to the data. Some of them have never seen a patent. So we need the patent data, we need the trademark data, etc. If we don't have a baseline, it's very difficult even to inform a policy or to inform RDB or other similar organisms in Africa. So we don't need only the data in the sense that what are they doing, which kind of intellectual property right they are using. We need also the why, so the motivation behind the use of these different intellectual property right and the combination of these different intellectual property right. And finally, what is most important for our economies, we need to know whether there is a clear or what kind of or how could we improve the link between IPR, innovation, and competitiveness? Because at the end of the day, we need competitiveness, we need growth, we need revenue. So even if we force all our startups to take patent and trademark, and they are not leveraging them to improve their position in the market, whether qualitatively or quantitatively, then we are not completing the job. So please the data and please more analysis so we can provide a better evidence to our policymaker. Now, just one sentence on smart specialization, and without coming back on the whole thing, because there may be some confusion between ICT-based strategies and smart specialization, which is a different concept. So just 2 sentences on this concept. Coming back, of course, to the IPR, it is really about stimulating innovation, so innovators like Pascal from the bottom up, at the same time checking that this is addressing our broader priorities. So it is a whole concept, but if we cannot protect the innovator, we cannot even think about how to implement such kind of innovation policy that are boosting the different potentials of our different regions within our respective countries. So not coming back on this, but just to say a few about this is really stimulating innovation. But if we cannot protect innovation and we cannot ensure innovation is translating into gain for the company, for the people there, and for our countries, then we are not doing the job.
In reference to the Africa Continental Free Trade Agreement that she mentioned earlier, and according to the World Bank data, they say that trade will increase by more than 50% in the next 5 years. That is up to the next 5 years, probably about 2026, and by 80% in the year 2035. So practically, how will we arrive at this kind of increase in trade, and which inevitably affect IP landscape, because the IP landscape is determined by economic growth and trade. So that is one question. So in my opinion, I'm seeing during the COVID season, e-commerce as a sector has grown exponentially. So with the uptake of e-commerce, this will break the boundaries of the boundaries or the borders the traditional borders we talk about or we hear about. So how is it relevant to this African Continental Free Trade Agreement? How is it going to be affected to see that this growth has increased? Because now we are having already challenges where we find it's difficult to prove that a mark is well known, because people are people. They're able to get onto their e-commerce platforms and get a product from country X and country Y, and then someone has not protected the mark in Rwanda and then say it is commonly known. So the government or Registrar General will find it difficult to prove that actually this product is already in the market, since everything is now online. So that's a new challenge, the new landscape, and we don't know how the law will try to address this new challenge and the new normal we are living in today.
Thank you for joining us for this conversation. I would like to extend also our thanks to our panel of experts.